information relating to criminal antecedent. Court mandate the disclosure of information relating to criminal antecedent, educational qualification, personal asset of a candidate contesting election. Lok Prahari versus Union of India 2018. Center directed to amend the rule as well as the disclosure form filed by the candidate along with the nomination paper to include the source of their income and those of their spouse and dependent and disclose of government contracts where candidate of their associate have direct or indirect interest. ये mainly election related case law है. लोक पहाड़ी वर्सेस यूनियन ऑफ इंडिया 2018. Lily Thomas versus Union of India 2013. 8 clause 4 of the Representation of People Act 1951 was prospectively that from the date of the decision struck down as unconstitutional being beyond the legislative competence of the parliament. Section 8 clause 4 provide that if an MP or MLA has been convicted of a criminal offence, such MLA or MLA can continue to remain and discharge his or her duties as a member of the house if within 3 months of the conviction he or she has first and filed an appeal or a revision against such conviction. This protection is no more available to MP and MLA, and thus on conviction they lose their seat. Then after Aviram Singh versus CD Commission 2017, Section 123, Clause 3 of the Act prohibits any candidate, his agent, or any person consented by such candidate or his agent from soliciting votes or discouraging voter against voting for rival candidate on ground of religion, caste, race, community, or language by declaring such conduct as a corrupt practice. The court has read this provision to disallow any reference to the religion, race, caste, community, or language of the candidate or his revival of the voters to secure vote or prejudice, means pakshpat, the electorate against a revival in an election. Ashwini Kumar Upadhyay versus Union of India 2018. MP और MLA cannot be barred from practicing in court. ये केस लॉ है जिन कारण कपिल सिब्बल सर हमारे अभी भी प्रैक्टिस कर रहे हैं कोर्ट में और राज्यसभा सांसद भी हैं. MP or MLA cannot be barred from practicing in court. Legislature cannot be styled or characterized a full-time salaried employee, for there is no relationship of employer and employee. Bar Council of India rules prohibit an advocate from being a full-time salaried employee of any person, government, firm, corporation, or concern as long as he continues to practice. 56. Public Interest Foundation versus Union of India 2018. Politician cannot be barred from contesting election on framing of charges. Guidelines issued to prevent criminalization of politics. First, while filing their nomination, the candidate must declare if there are pending criminal case against them in court. Second, political party also responsible for putting up detail of criminal case filed against their candidate on their website. Third, Parliament must legislate on the matter to ensure that candidates with criminal antecedent do not enter public life or become lawmakers. शर्ला मुद्गल का केस आया वर्सेस यूनियन ऑफ इंडिया 1985, जिसमें यूनिफॉर्म सिविल कोड की बात की गई है, इम्फेस्ड ऑन द नीड फॉर अ यूनिफॉर्म सिविल कोड. Then after in Ray Keshav Singh 1965, it could not dispute that in the matter of privilege, the House was the sole and exclusive judge provided such privilege could be found in Article 194 Clause 3. The question whether a privilege as claimed by the House was provided by Article 194 Clause 3 or not was a matter of the court to decide. The nature and scope of Article 194(3) was thus to be determined by the court. The court also observed that such privilege were necessarily subjected to Article 21 and 22 of the Constitution. PV Narasimha Rao versus State 1998. The court held that those who took bribe but did not vote will be liable. The court held that those who took bribe but did not vote will be liable for prosecution under the Prevention of Corruption Act as they were not protected or entitled to the immunity under Article 104 Clause 2 of the Constitution, whereas those who voted will be protected even though they had taken bribes. Swapnil Tripathi versus Supreme Court of India 2018. Supreme Court allowed live streaming of court proceeding. Ilya Singhal versus Union of India 2015. Supreme Court struck down Section 66 of IT Act 2000 relating to restriction on online speech on grounds of violating of freedom of speech granted under Article 19 Clause 1A Constitution of India. Joseph Frank versus Union of India, Section 497 relative of Indian Penal Code is codified law of patriarchy. The bench held Section 192 Clause 2 of the CRPC, which gives the husband has exclusive right to prosecute his wife, a lover, manifestly arbitrary. Then after K. Puttuswamy versus Union of India, upheld Aadhaar as a reasonable restriction on individual privacy, upholding the passage of the Aadhaar card as a money bill. The majority opinion upheld the PAN Aadhaar linkage but declared linking Aadhaar with bank account and mobile SIM card unconstitutional. The card was not necessary for children aged between 6 and 14 under the Sarva Shiksha Abhiyan, as right to education was a fundamental right. Statutory bodies like CBSE and UGC cannot ask a student to produce their Aadhaar card for examination like NEET and JEE. Section 57 of the Aadhaar Act was struck down as it was used by the government to compel private companies to demand Aadhaar verification for service. 64. Young Indian Young Lawyer Association versus State of Kerala 2018. Exclusion of women from Temple of Lord Yappa was a discriminatory practice which violated the freedom of religion of women devotee. Devotee of Lord Yappa do not constitute a separate religious nomination on the provision of a woman is not an essential part of Hindu religion. Also, exclusion based on the notion of impurity. Menstruation is a form of untouchability. ये केस तो था आपका सबरमला टेम्पल जो केरला में है उस रिलेटेड है इंदिरा इंडियन यंग लॉयर्स एसोसिएशन वर्सेस स्टेट ऑफ केरला। उसके बाद नवतेज जोहर वर्सेस यूनियन ऑफ इंडिया का केस था जिसमें 377 आईपीसी इज इरेशनल indefensible and arbitrary. The sexual orientation of each individual in the society must be protected on an even platform for the right to privacy, and the protection of sexual orientation lies at the core of the fundamental right guaranteed by Article 14, 15, and 21 of the Constitution. Respect of for individual choice is very essence of liberty under law. Section 377 IPC assumed the characteristic of unreasonable for became weapon in the hand of majority to seclude, exploit, and harass the LGBT community. Ola Telis versus Bombay Municipal Corporation 1985. Right to livelihood in the facet of Article 21 of the Constitution. Right to livelihood के बारे में बात की थी ओल्गा तेली में. John Belton versus Union of India 1967. Court declared Section 118 of the Indian Succession Act unconstitutional as violating of Article 14 of the Constitution. It restricted the right of a Christian having a nephew or niece or any other relative as regard his power to bequeath his property for religious and charitable purpose. DC Wadhwa was the state of Bihar 1987. The power to make an ordinance is meet an extraordinary situation and it should not be made to meet political ends of an individual. Repromulgation from time to time is supervision, the democratic process, and the fraud on the constitution. If ordinance making was made a usual practice, creating an ordinance raj, the court could struck down repromulgated ordinance. Krishna Kumar Singh versus State of Bihar 2017. Krishna Kumar Singh versus State of Bihar 2017. The court held that recruitment of placing the ordinance before the legislature is mandatory. Repromulgation of ordinance is a fraud on the constitution and the supervision of democratic legislative process. The court also held that the satisfaction of the president under Article 123 and of the governor under Article 213 while issuing ordinance is not immune from judicial review. A.K. Roy versus Union of India 1982. President ordinance making power is not beyond the scope of judicial review. However, the need to exercise judicial review over the president decision arises only when there were substantial ground to challenge the decision and not every casual of passing challenges. ATM Jabalpur versus Sivkant Shukla 1976. The issue was whether an order issued by the President under Article 359 Clause 1 of the Constitution suspend the right of every person to move any court for the enforcement of the right to personal liberty under Article 21 upon being detained under a law providing for. The court answered in the affirmative overruled in K. Puttaswamy versus Union of India. VP Singhal versus Union of India 2010. The president, in effect, the central government has the power to remove a governor at any time without giving him or her any reason and without granting an opportunity to be heard. However, this power cannot be exercised in the arbitrary, capricious, or unreasonable manner. The power of removing governor should only be exercised in the rare and exceptional circumstances for valid and compelling reason. The mere reason that a governor is at variance with the policies and ideology of the central government or that the central government has lost confidence in him or her is not sufficient to remove a governor. Thus, a change in central government cannot be ground for removal of governor or to appoint more favorable person to this post. A decision to remove a governor can be challenged in the court of law. 73rd, Society for Unaided Private School of Rajasthan versus Union of India 2012. Every citizen has right to establish an administrative school under Article 19, 1 Clause G, so long as the activity remains charitable. Such an activity undertaken by the private school supplement the primary obligation of the state. The state can regulate by law the activities of private school complaint, and the state can regulate law activities of private school, including admission, by imposing reasonable restriction in the public interest under Article 19, Clause 6 of the Constitution. The quota obligation imposed on private unaided non-minority school is the public interest and is a reasonable restriction for the purpose of Article 19, Clause 6. Therefore, the Right to Education Act shall apply to private unaided non-minority school. Regarding unaided minority school, Article 29, Clause 1 of the Constitution protect the right of the minority to conserve their language, script, or culture, and Article 30, Clause 1 protect their right to establish and administer a school of their choice. Imposing a quota on such a school would result in changing their character and would therefore violate this minority right. Therefore, the RTE Act shall not apply to unaided minority school. Regarding government aided minority school, Article 29, Clause 2 of the Constitution protect every citizen right to admission into a state aided school. Accordingly, the RTE Act shall apply to aided minority school. Samati Educational and Cultural Trust versus Union of India 2014. Society for Unaided Private School of Rajasthan versus Union of India and another, insofar as it holds that the 2009 Act is applicable to aided minority school, is overruled. Constitution 93rd Amendment Act 2005 inserting clause 5 of Article 15 of the Constitution and 86th Amendment Act 2002 inserting Article 21A of the Constitution does not alter the basic structure of framework of the Constitution and are constitutionally valid. RTE Act is not ultra vires. Article 19(1) Clause G of the Constitution. S.R. Bomai versus Union of India. The Supreme Court laid down certain guidelines so as to prevent the misuse of Article 356 of the Constitution. Based on the report of Sarkaria Commission on Central State Relation 1988, the Supreme Court enlisted the situation where the exercise of power under Article 356 could be proper or improper. It so held that secularism is one of the basic features of the Constitution. Secularism is a positive concept of equal treatment of all religion. Any state government which pursues non-secular policies or non-secular courses of action act contrary to the constitutional amendment and render itself amenable to action under Article 356. Ismail Faruqi versus Union of India 1995. The power of acquisition is the sovereign or prerogative power the state to acquire property. Such power exists independent of Article 300A of the Constitution. For the earlier Article 31 of the Constitution, which merely indicate the limitation on the power of acquisition by the state, such acquisition as per does not violate Article 25 or 26 of the Constitution. What is protected under Article 25 and 26 is religious practice which form essential and integral part of religion. A practice may be religion practice but not essential part of religion practice. While offer of prayer or worship is a religious practice, is offering at every location where such prayer can be offered would not be essential or integral part of such religious practice unless the place has a particular significance for that religion so as to form an essential or integral part thereof. SP Mittal versus Union of India 1983. The word religious denomination in Article 26 of the Constitution must be take their color from the word religion and is if this is to be so, the expression religious denomination must also satisfy three conditions. It must be collection of individual who has a system of belief or doctrine which they regard as conducive to their spiritual well-being. That is common faith, common organization, and designation by a distinctive name. The Commissioner Hindu Religious Endowment Madras versus Sri Lakshmidhar 10th Swami or Sri Smooth 1994. The court laid down the essential practice test. It observed what constitutes an essential part of religion will be ascertained with the reference to the tenet and doctrine of that religion itself. The essential religion practice test means that any religion's practice which form the basic or is to essential so that the religion that it fall within the protection of Article 25 and 26 should be protected as such. Any other activity is not an essential practice, does not require protection and will covered in exception to the right of religion. There are certain exceptions which are given in the Constitution itself, like economic, political, and financial or other secular activities which may be associated with religious practice. Selvi versus State of Karnataka 2020, court declared that three prominent police interrogation technique narco analysis, the lie detector test, and brain mapping violated an accused person right against self-incrimination under Article 20, Clause 3 and her right to life and personal liberty under Article 21 of the Constitution. A forcibly administration of the above test would be unjustified instruction into mental privacy and conclude lead to a further stigma for the victim. Then after MC Mehta versus Union of India laid down the concept of public liability and absolute liability, rural litigation and entitlement. Kendra Dehradun versus State of Uttar Pradesh 1997 laid down the concept of sustainable development. Indian Council for Inward Legal Action versus Union of India 1999 laid down the polluter pays principle. Animal Welfare Board of India versus A. Nagaraj 2014 court prohibited Jallikattu and other animal races and fights, held that animal fight incited by human are illegal, even those carried out under the guise of tradition and culture. Then after Subhas Kumar versus State of Bihar 1991, a right to life includes right to enjoyment of pollution-free water and air for full enjoyment of life. DK Vasu versus State of West Bengal. DK Vasu versus State of West Bengal 1987 court laid down specific guidelines required to be followed by police while making arrest. Sila versus State of Maharashtra 1983 court laid down guidelines conferring protection to women prisoner in police lockup. And Premchand Garg was exercise commissioner UP Allahabad 1963. The court held that an order which this court can make in order to do complete justice in under Article 142 between the parties must not only be consistent with the fundamental right guaranteed by the Constitution, but it cannot even be inconsistent with the substantive provision of the relevant statutory law. Union Carbide Corporation was Union of India 1981. The court held the provision of limitation or provision contained in ordinary law cannot ipso facto act as provision or limitation on the constitutional power under Article 142. Supreme Court Bar Association versus Union of India 1998 court observed that power under Article 142 cannot in any way be controlled by any statutory provision, but at the same time these powers are not meant to exercise when the exercise may come directly in conflict with what has been expressly provided for in statute dealing especially with the subject. It was laid that the said article could not be used to supplement the existing law but only to supplement the law. Subhas Mahajan versus State of Maharashtra 2018 court laid down guidelines to prevent abuse of the scheduled caste and state prevention of atrocity act 1989 CST act held no absolute bar on anticipatory bail. Arrest to be made after the preliminary inquiry. Public servant cannot be arrested without prior sanction. Government of NCT of Delhi versus Union of India 2018, the court held that Lieutenant Governor of NCT of Delhi is bound by the said ad and advised to be elected government of Delhi except in matter of land, police and public order. While holding so, the court has observed that in democracy, real power must vest in the elected representative and Lieutenant Governor cannot interfere in every decision of Delhi government. The word any matter employed in the proviso to clause 4 of Article 239 AA cannot be inferred to mean every matter. Maru Ram versus Union of India 1980, court held that the power under Article 72 is to be exercised on the advice of the central government and not by the president on his own, and that the advice of the government bind the head of the republic. Kehar Singh versus Union of India 1989, the court laid down that the order of the president cannot be subjected for judicial review on its merit except within the strict limitation defined in Meru Ram. Ipru Sudhakar versus Government of AP 2006. It is a bill set principle that a limited judicial review of exercise of clemency power is available to the Supreme Court and High Court. Granting of clemency by the president or governor can be challenged on the following ground. The order has been passed without application of mind. The order is malified. The order has been passed and extraneous or wholly irrelevant consideration. Relevant material has been kept out of consideration. After Trivenimum versus State of Gujarat 1989, undue long delay in execution of the sentence would entitle the convict or to approach the Supreme Court under Article 32 or the High Court under Article 226 and get his sentence commuted. Then after Satrughan Chauhan versus Union of India 2014, the court observed that an inordinate and inexplicable delay in execution would preclude carrying out the sentence even in cases where the convict in question had committed an offense of terrorism. Overruled Devendra Singh Bhallar versus State of NCT Delhi 2013, which had ruled that a delay in disposition of a mercy petition was by itself insufficient ground for commuting the sentence of those convicted to death under anti-terrorism statute. Union of India versus Tulsiram Patel 1985, the court held that the dismissal, removal, or reduction in rank of a person convicted on criminal charges is in public interest, as therefore not violating of Article 311 Clause 2 of Article 14 of the Constitution or the Article 14 of the Constitution. Purushottam Lal Dhingra versus Union of India 1957, Article 3111 is available only when dismissal, remove, reduction in rank is way of punishment. So it is difficult to determine as to when an order of termination of service or reduction in rank amount to punishment. The Supreme Court laid down two tests of determine when termination is by of punishment, whether the servant has a right to hold the post or the rank, whether he has been visited with evil consequences. If a government servant has a right to hold the post or rank under the terms of the contract of service as under rule governing the service, when the termination of the service or reduction in the rank amount to be punishment, and he will be entitled to protection under Article 311, Article 310 and 311 apply of government servants, whether permanent, temporary, officiating or on provision, or the procedure laid down in Article 311 is intended to ensure first to measure a tenure or to government servant whether a covered article, and secondly to provide certain safeguard against arbitrary dismissal and removal of government service and reduction of lower line. Union of India was Balbir Singh 1988. The Supreme Court held that the court can examine the circumstances on which the satisfaction of the president or governor is taken under provision of Article 311 Clause 2. If the court find that circumstances have no bearing whatsoever on the security of a state, the court can hold the satisfaction of the president or the governor, which is required for passing such an order, has been visited by wholly extraneous and irrelevant consideration. And the last one is campaigning for judicial accountability and reform versus Union of India 2017. Chief Justice is the master of the roster, followed the ratio of the state of Rajasthan versus Prakash Chand 1998. Thank you.